seated. The case is SC 2013-06. It is the challenge to certain eligibilities of candidates who have filed for office of Cherokee Nation Council. I would ask the attorneys to make announcement as to their representation. And Mr. Cole, I'd begin with you.
Yes, Your Honor. David Thornton is present in court with his counsel, Lloyd Cole.
Thank you, Mr. Cole.
James Prozek, representing Meredith Fraley, who is present here in court as well.
Thank you, sir.
A.J. Garcia, representing petitioner Robin Mays, who is present.
Thank you, Mr. Garcia. I'm going to defer for the first announcement.
Yes, Your Honor.
I'm sorry, Mr. Smith.
Thank you. Chad Smith appearing for Jack Baker and Don Garvin. They appear today.
This is Chuck Oscar Jr. appearing for myself and Curtis Snell. Mr. Snell's not here. His wife is ailing.
Thank you, Mr. Hoskins. And I apologize, Mr. Smith, I didn't see you there. Thank you, Mr. Chapin. And I will now defer to Justice Wilcoxon for the first announcement.
As a preliminary matter, the court notes that a motion was filed for recusal of two unnamed justices on grounds of participation as delegates to the 1999 Constitutional Convention. That has been considered by the court, and it is denied.
All right. The court has also considered some additional motions that have been filed, and we are making some rulings without the necessity of argument. The motions to disqualify attorneys Chad Smith and Mr. Hoskins Jr. Are denied. The motion to strike responses as untimely filed by Mr. Mays are denied. There was a Friday holiday, and the court finds that those responses were timely filed. We are here today under an accelerated proceeding under LA 06-10, Section 37, and we are here to hear the challenges to the eligibility of candidates for office. And that is the court's jurisdiction today as to the subject matter. Issues have been raised by Mr. Mays, both before the Election Commission and before this court by way of appeal, that, in the opinion of this court, do not relate to the eligibility of the candidates for office. And therefore, the issues that were raised before the Election Commission regarding the eligibility of freedmen to vote and whether or not Mr. Mays will be serving in a de facto office, the checking of background information of candidates, the delayed certification of elections, and the designation of poll watchers. We believe these issues are not, we believe that these issues were properly denied before the commission and are not properly before this court under the limited jurisdiction that this court is exercising under Section 37 of the Act. And therefore, these issues will not be before this court and not be heard today. Are we in agreement? All right. We had a motion to continue the matter by Mr. Garcia because, and we understand, Mr. Garcia, that well, I understand your situation, and the court is mindful of that. However, because, again, of the nature of the proceedings being accelerated under this statute, we were not at liberty to extend the time, and therefore your motion to continue the matter would be denied. Now, with that announcement, we're ready to go forward, and I believe it would be appropriate, Mr. Garcia, for you to go forward with your remaining motions and your petition, and to present. Yes.
Well, Your Honor, as a kind of a preliminary issue to presenting the evidence on the remaining challenges that remain within the petition, Mr. Mays presented his challenge to the election board requesting a determination of whether or not he would be a de facto candidate that this court has expressed that it is already determined is not before the court or would not be before the court. Respectfully, we would submit that based upon the evidence that we intend to present today, that issue needs to be addressed. In effect, Mr. Mays requesting a determination of his status, whether or not he would be a de facto candidate, is actually his own challenge toward his own potential candidacy, and the evidence that we intend to present would give rise to that question. We intend to present evidence to this court that may call into question its prior decision from the case in re the implementation of the 1999 Constitution, JAT 0504. There's been new developments, new evidence, new facts that have been presented by the U.S. Department of Interior, the Bureau of Indian Affairs, that need to be addressed with that. Additionally, we would also be raising a legal issue that this court failed to determine or take under advisement, apparently, at the time of rendering its decision, that there was legal precedent of the Judicial Appeals Tribunal dating back to issued in 1998 under case number JAT 9601 that was restated and reaffirmed as recently as I could find in case number JAT 0409, Allen versus Cherokee Nation Tribal Council. The first citation was for the JAT 96 case was DeMoss versus Jones et al. There are several defendants there. Based on that legal premise, it would call into question this court's decision under the in re the implementation of the 1999 Constitution. And if this court were then to determine that there was an error made in that determination, it could affect even Mr. Mays' candidacy, much less any of the other issues. So we would respectfully request this court, by oral motion here today before this court, to vacate its decision preliminarily announced that this issue would not be before the court, because he's actually challenging his own candidacy. And we believe that we'll be able to at least present evidence toward that, or at least allow us to present that evidence and make a determination of whether or not the court could continue to hear and rule on that decision, or whether it will stand on its prior announcement.
Would you briefly tell me what his grounds is for challenging his own candidacy?
Well, Your Honor, this court in JAT 0504 determined that the 1999 Constitution, as it was ratified by the voting citizens of the Cherokee Nation in July 26 of 2003, would be implemented as of that date. But if there is an issue, which we present that there is evidence that there is an issue, I filed a notice pursuant to the Federal Rules of Evidence, Section 807, of our intention to introduce documentation from the Bureau of Indian Affairs of the Department of Interior, letters that we intend to introduce that were not available at the time, expressing the department's position that the effective document for governance of the Cherokee Nation is still the 1975 Constitution, that they did not approve of the amendment to the 1975 Constitution, Article 15, that would have repealed the requirement for federal approval before enactment of any further amendments or anything else. Thus, if the Department of Interior did not approve of that amendment, and I think that election was in May of 2003, then the subsequent ratification of the voters in July of 2003 regarding the implementation or enactment of the 1999 Constitution would be invalid, because there was never any federal approval issued under the 1999 Constitution. So it goes all the way back to whether or not the Department of Interior did approve. And I know this court has received evidence and testimony in that case, JAT 0504, and rendered its decision. However, we have a statement, we have a position, affirmative position of the Department of Interior that says that their position is the controlling document is still the 1975 Constitution, and that there was no approval of the amendment from the May election of 2003. And if that is the case, that their position should not, or is valid, that there is no approval, that would negate the implementation of the 1999 Constitution. Mr. Mays is running on an at-large seat that, as I understand it, would have been implemented under the 1999 Constitution, so it challenges his candidacy as well. This court should determine those issues. Additionally, we're challenging his candidacy through the failure of this court in issuing its decision under JAT 0504 to adhere to this court's expressed determinations and decisions of constitutional interpretation as announced in DeMoss versus Jones et al., JAT 9601, where this court would be required to look distinctly and directly to the language on the face of the Constitution. And if that's the case, or any constitutional amendment, it's an interpretive issue. This court has added in other issues for interpretation for when things would be implemented and how this would enact, that still would lend rise to challenging even Mr. Mays' candidacy. And he is presenting that for decision.
Is Mr. Mays seeking to challenge his own candidacy on the grounds that the 1999 Constitution is of no effect?
Yes.
And at the same time, challenging the candidacy of the other candidates on the grounds of violation of term limits under the 1999 Constitution?
That would be an alternative theory if this court were to find that the 1999 Constitution were valid, that then the subsequent decisions of the implementation of the term limits and on what date they would apply would necessarily need to be reviewed. And again, based on this court's same lack of following its precedent from DeMoss and subsequently issued under Allen, that the court looked beyond the black letter language of that constitutional provision. That constitutional provision related to term limits specifically said that they shall not serve more than 2 consecutive elected terms. It did not implement a start date, but just based on the black letter of the law, if that 1999 Constitution were in effect, or when it becomes effective, that would begin to look at, all right, we now have the next election coming up, and you look back at the candidates. You look back and see, have they already served 2 elected terms? Because it's very clear, very black and white. When the new Constitution becomes effective, you look very specifically. They shall not serve 2 consecutive terms. To put a prospective date to the application of when your terms begin to run for the purposes of the 1999 Constitution is beyond the black letter of the law. And that interpretation, read it under the black letter of the law as it was known and understood by the voters at the time it was voted on, comes directly from DeMoss. DeMoss adopted the Oklahoma court case of, and let me find it again, First American Bank and Trust Company v. Purcell, or of Purcell versus Oklahoma Industrial Finance Authority, a 1997 Oklahoma Supreme Court case. They specifically adopted that ruling, and that was recited with extreme favor, again, in Allen versus Cherokee Nation Tribal Council, JATO 409. So this court didn't even address its own precedent when it made that decision. So alternatively, if this court finds the 1999 Constitution to have been effective as of that date, the issue of whether or not the term limits are being exceeded is still potentially raised under an alternative theory. And then again, with the implementation of the time as the council and approved by this court in Supreme Court case 0903 said that they approved of the council's, I think it was LA 07, I could have that wrong, implementation or procedure to stagger these elections. The black letter of the Constitution says that a council member shall hold a term for 4 years. It does not say by the black letter of the law that a council member shall or may hold a term for 6 years. This court failed to take into account its own precedent in reading the black letter of the Constitution pursuant to its own precedent when it approved the council's determination of how to implement the staggered election purposes. We are not challenging that if the 1999 Constitution is determined to be effective and valid, that they would have had to have implemented some plan to stagger the elections. But to go beyond the black letter stated term of 4 years in the Constitution and ignoring the precedent of this court to read that exactly as it stands and allow the council to establish a 6-year term in order to stagger when they could have enacted 2 3-year elections, it would have fit within and underneath the 4-year limit. Or a 2-year election at the first outset, which has been done in many, many cases. And had I more time to present this as we had requested, but I understand, and we may request the court later on to hold open the record. I'm not sure yet because we still have, I believe, 3 days left. Not to go off on a tangent, but the council could have enacted legislation to establish and enact and put enforcement to the Constitution within the bounds of the black letter of the Constitution as it was. And unfortunately, they didn't. And unfortunately, this court approved it, ignoring its prior precedent that's been in place since 1996. Therefore, we are requesting this court to allow us to present the evidence that we do have, number one, about the Department of Interior's position regarding the Constitution and take that issue and rule on it and make a decision on that issue. Because there's open litigation right now. The Nash case, the Cherokee Nation versus Nash case out of the Northern District of Oklahoma, still is an open case. There has not been a ruling upon that, and that issue, although it is mostly surrounded by the issue of whether or not the freedmen are still to be considered citizens for voting purposes, it's still going to have to go all the way back to the implementation of the amendment deleting the 1975 constitutional Article 15 requirement of federal approval.
Mr. Garcia, not to interrupt you, and appreciate your argument, but could you tell us in 5 minutes, say, give us a summary of what your evidence would be if we did let you put it on? What would it be? We say you have a letter from the Department of Interior, and what else do you have that you would put on if you were allowed to put it on?
In case number 03-CV1711, in the U.S. District Courts for the District of Columbia, the Van versus Cherokee Nation and et al. Case.
The Van decision.
The Van case, yes. There were documents introduced in that case directly from letters written by the U.S. Department of Interior, specifically a letter dated September 9th, 2011 from Larry Echohawk, where he states that the Department of Interior did not approve any amendment to the 1975 Constitution that would do away with the federal approval requirement until sometime around August of 2007. So the effective date of the approval of an amendment deleting the federal approval requirement, according to the Department of Interior, is in 2007.
What else do you have?
I have in the same case, filed in the same case, an affidavit of the Assistant Secretary of Indian Affairs from May 25th of 2007, Carl J. Artman, expressing his position, or the department's position, under paragraph 7H, page 3 of that. The department considers the 1976 Constitution, referring to the Constitution that was proposed and enacted, I guess, in 1975 and approved by the department in 1976, to be the governing document of the Cherokee Nation for the department's purposes.
What else do you have?
I have two more letters, one dated August 30th of 2006, addressed by James Kaysen to then Principal Chief Chad Smith, stating, "Thank you for your letter of June 9th, 2006, advising me the Cherokee Nation was withdrawing its request for approval of the Cherokee Nation." So up to that point, the Cherokee Nation, through the Principal Chief, was admitting the need for continued approval by the Department of Interior.
What else do you have?
And then I have another letter dated in 2007 restating the fact that the department's position, and that was in March of 2007, that the 1975 Constitution was controlling.
And what else do you have?
Those are the four documents that I have at this point.
That's the evidence that you would put on if we were to allow you to put it on, correct?
Yes, Your Honor.
And we have those documents.
Yes, Your Honor, you
Okay.
do.
Do you have any other arguments that you wish to make?
Well, with regard to that
Now,
issue.
counsel, you were making argument on the term limits issue and on the serving 6-year on a 4-year term. Are you going outside of the initial argument you were going to make about the effectiveness of the 1999 Constitution? Have you made all of your arguments, in other words?
Well, and I didn't mean to go outside of the initial argument, but one necessarily follows from the other. I need to review my notes on my argument. I was kind of planning to do this as a presentation of testimony and evidence first, but I believe we've basically covered it. The only other issue I believe that I would address at this point is another persuasive authority to bolster our need for this court to render a decision on the effectiveness and the implementation of the 1999 Constitution is a persuasive case from the state of South Carolina related to officials and their official capacity, because as I understand it, much of the decision initially in the JAT 0504 case, this court relied on an affidavit from Neil McCaleb that stated in 2006, well after the elections, and while he was not the officer in his position previously with the Department of Interior, that of what his intention was. Under the McDowell case, once an officer is terminated from their employment, their authority is over. He has no way, shape, or ability to bind his successors, and that is laid out in the exhibits that we intend to introduce as evidence for the position of the Department of Interior and the Bureau of Indian Affairs regarding the 1999 Constitution versus the 1975 Constitution. So that issue wasn't even presented, although, I mean, the court may or may not take that because it's merely persuasive authority. But, you know, we have those issues that arise to create a need for this court to review its previous decisions. If I may have a moment, I'm kind of reviewing. I think I've done this backward and presented my argument before I presented my evidence. The only other issue, and Mr. Mays did not specifically raise this before I became involved, and as I dug through this issue and over the weekend trying to wrap my head around it, it came to light to me that there are possibly two justices on this panel whose position on this panel depends on enforcement of the effectiveness and implementation of the 1999 Constitution, as was previously stated in the JAT 0504 case. If that is the case, that may lend itself to a possible, losing it here, a possible conflict of interest that I believe that the Supreme Court may want to review and address prior to determining these issues, because if we're challenging the effectiveness of the Constitution, yet two justices would rely on the effectiveness of that Constitution for their seat, how is that going to continue to affect their decision? And I'm not saying, based on what legal precedent that I've found so far, that if this court were to determine the invalidity of the 1999 Constitution, that it would necessarily affect some of the rulings or any of the rulings necessarily that have been made so far, other than what may be affected by other legal precedent or the need for new facts to redetermine, because this court made its determination and acted upon it in good faith up to this point. But I think this court may want to consider whether any of its justices would be affected by the need to review the 1999 Constitution before rendering a decision. And I don't remember whether the court addressed whether or not Mr. Mays will be able to discuss his concerns about the freedmen being allowed to vote in this election, because apparently he feels he has testimony or evidence to present that there are applications for voting ballots that are not being processed.
Tell me how that fits within Section 37's restrictions.
I believe he raised that issue at with the election board at the hearing.
But how does it affect the eligibility of a candidate for office?
Well, and it may not necessarily affect the eligibility of the candidate for office. Well, and he brings up a good point that I wasn't thinking of at the time. This may result in another election challenge, but that may not be before this court at this time, and this court may have to wait and resolve that issue if there are challenges presented based on freedmen not being permitted to vote in the upcoming election this year. So, I believe at this point in time, I think that's going to be all we have to present to the court as far as what we would intend to introduce. And
Do the justices have questions of Mr. Garcia?
yes, Your Honor.
I'm see if the justices have any questions. All right, thank you, sir. Just a moment. Oh, is there any question? They don't need to. If they want to. Do we want to revisit the case? Do you all want to revisit the case? All right. Okay. Can I see that? Our court has discussed the question of whether or not our Constitution of 1999 is in effect. We are not inclined, and without further argument from the other parties, the court is not inclined to revisit the decision we made in JAT 0504 that the 1999 Constitution of the Cherokee Nation was in full force and effect upon certification of the election of its passage in 2003. We have heard argument this morning with regard to the federal position. We addressed the federal position with regard to our Constitution when we issued our opinion in JAT 0504. And that was in 2006. That was 7 years after the Constitution was drafted, and it was 3 years after the Constitution was voted on by the people that we retroactively found that it was effective upon the vote of the people. We now set almost 10 years after the people voted on the 1999 Constitution, and still the question of federal approval is raised. I know that in the previous case of 0504 that I stated, that even in 2006, the Cherokee Nation was not obliged to wait on federal action for our people to go forward with their Constitution. And I still feel that is true, and even more true today. We have placed many children through our courts through the strength and upon the strength of the 1999 Constitution, which replaced in total previous constitutions of our nation. And so this court is not disposed to revisit that decision. That decision is affirmed today that our 1999 Constitution was, from the time of the vote of the people, in full force and effect. And so I think, to the extent that addresses Mr. May's challenge to his own candidacy, and in whatever way it might affect the other issues raised, that will be the decision of our court, and the court agrees, and we are unanimous in that decision. With that, if the other attorneys wish to be heard upon the argument that has been made, I know that counsel's argument has gone to issues of term limits and to issues with regard to the extension of the terms of candidates, of council members. If you wish to address those issues, the court will hear you. Mr. Cole, is there anything you wish to say?
No, Your Honor, I think the court has done as I anticipated it will. You have precedent already been established. I happen to be a part of some of that litigation. I know the extent to which the court looked into behind across all of the decisions and arguments that were made, and I think it was a correct decision. We've been operating on that. I've heard nothing here today to suggest that the court should do anything other than reaffirm its position. It's kind of unique that we have a candidate here who has been ruled eligible to run at large, who challenges his own candidacy and tries to broaden it out in such a manner that we have here today. Leads me to believe that our argument today is that this is a frivolous action and that these candidates should be reimbursed their attorney fees with regard to it. That matter is still remains.
I think we've received such requests from all counsel, I believe, and those are will be under advisement. Would you pronounce your name again for us, please?
Prozac, Your Honor.
Prozac. Thank you, sir.
Like the drug.
Thank you. Thank you.
Your Honor, if I might add, when the court takes the position today that it's reaffirming the decision that it made in 05, JAT 0504, in that decision, the court also addressed the issue of when the term limits commenced, and that is a part of the argument that we've raised in our brief. So the term limits, the effective limits of 2 consecutive terms, did not begin until the election that was held in 2007 after the 1999 Constitution became effective. So if the court is today reaffirming the holdings in JAT 0504, that would seem to dispose of the issue of whether any of the candidates are seeking an improper third term. I would also point out that in the Smith versus Election Commission case, which was decided in June of 2010, the court did in fact reaffirm that position. So there's not just one case so holding. There are in fact 2 cases that have addressed the issue of when the term limit began. So we now have 2 decisions from this court affirming that nobody is improperly running for a third term.
Argument was made about the staggering process granting candidates or office holders more than 4 years, and that would violate the Constitution. What's your position on that?
Your Honor, again, there is precedent on it. That argument was briefed extensively, both in the district court and this court, in the Smith versus Cherokee Nation Council, or excuse me, Election Commission and the council. And this court found that the staggered terms was within the jurisdiction the Constitution awarded to, or the discretion that the Constitution awarded to the council. Yes, the council had choices. It chose to make the choice to implement the staggered terms by implementing a 6-year term. That was argued and that was addressed in this court's June 2010 decision in Cherokee Nation versus Smith. Council talked about the black letter of the law. The Constitution left it to the council to determine how the staggered terms would be implemented. It instructed the council in its discretion to come up with a system for enacting the staggered term mandate of the council. In implementation of the 1999 council, this court specifically instructed the council to exercise that discretion before the 2007 election and to come up with a procedure to implement the staggered term. The procedure that the council chose under the discretion granted to it by the 1999 Constitution was the 6-year term. This court, in June of 2010, affirmed the council's exercise of its discretion. And perhaps more importantly, even if the council were incorrect, even if this court decided to revisit the June 2010 decision, that does not provide a ground for challenging the candidates in this election. At worst, they were improperly in office today. It does not prevent them from seeking election in the 2013 election.
That it? Thank you.
Yes, Your
Questions of the attorney? Mr. Smith, you have any comment or argument as to what Mr. Garcia has argued?
Your Honor, the court's decision in the implementation of the Constitution was one of those moments in history that we can all be proud of. It was the extreme and the ultimate exercise of sovereignty, where the United States repeatedly said we would approve the referendum to remove ourselves from your constitutional house. They delayed the ministerial execution of that, but they certainly did approve exiting our Constitution.
Mr. Smith, forgive me. My battery went out of my hearing aid, and I'm having trouble hearing you this morning. Speak up for me just a little bit.
I will, Your Honor.
Thank you. And I'll try to do the same.
The implementation case, the court's decision in the implementation case, was the ultimate exercise of sovereignty. We got to choose. This court got to choose. Our people got to choose the effective date of our highest law of the land, the Constitution. And the federal government's post-decision letters are but opinion by them, which is not effective on us. They had the opportunity and were summoned to participate in that decision in 05 and 06, chose not to. Neil McCaleb was very clear that he approved the referendum. He subsequently didn't ministerially execute it, but he approved the referendum. The people voted not once but twice.
Thank you.
Your Honor, may I briefly correct a statement I made? I referred to the Cherokee Nation versus Smith as a June 2010 decision. I was confusing it with the earlier in Ray 1999 Constitution, which was issued in June. The decision to which I was referring, Cherokee Nation versus Smith, was actually February 4th of 2010, and it's SCO 903. I apologize for that mistake.
I think we understood that. We caught it, I hope. Who's next? Mr. Hoskins?
Justices, just briefly, representing myself and Mr. Snell insofar as Mr. Mays' challenge to the 6-year staggering term issue. Difficult to put it better than Mr. Prozac put it. The very last point he hit on, though, I think is the threshold issue. I think it's where your analysis begins and ends, which is even assuming Mr. Mays can state a successful case that the 6-year term is unconstitutional. I believe that he can't. We briefed that. It does nothing to disqualify myself or Mr. Snell or any similarly situated candidates because the election code and the Constitution prescribes what the qualifications are. Even assuming he were to say we were in some sort of an extra constitutional term, it would not render us unqualified. It would not affect our meeting of the age requirement, residency requirement, blood requirement. It simply wouldn't affect anything that this court needs to rule on. So I would suggest that your analysis begins and ends quite simply on that threshold issue, and the challenge should be dismissed. Thank you, Your Honor.
Thank you. Mr. Chapin, anything?
I have one brief comment, Your Honor, not just before.
That's fine.
The Election Commission heard the evidence from Mr. Mays, and they were aware of and based their decision on the Smith versus, or Tribal Council versus Smith case, the February 2010 case. They felt that that case addressed the issue, was on all four corners with facts as presented to them, and they didn't feel it was appropriate for them to change the law as it stood at that time, and left it to the big courts to do that if they desired to do so. They felt the established precedent required them to do what they did, and it was in their province to change the law.
Thank you. Is there anyone else to be heard?
Your Honor, if I may, the issue
You may respond.
The issue of the frivolity of Mr. May's claims has been raised, and we have not had an opportunity to respond to that specifically. It's Mr. May's position that, given the position of the U.S. Department of Interior and their repeated statements and repeated position that they did not find the 1999 Constitution to be the effective document, that gives him in and of itself sufficient fact to at least make his challenges to request this court to redress even his own candidacy because of the lack of real knowledge of whether or not this court would stop and look back at it, especially given the light, which is one of the other issues or elements to look at when you're looking at a stare decisis doctrine, is the fact that there's nothing in the court's decision back from 05 or 09 that mentions its prior precedent established in 1996 under the DeMoss case for looking at the black letter of the law exactly as it's written. You look clear and cut on the face of the language before going behind it to the intent, because that's what those decisions focused on, was the intent of the framers. It didn't say anything about ambiguity. It went to an intent to determine when should this begin, when should these issues start to arise. So looking at the precedent of this court and the fact that it was failed to be addressed in those previous decisions grants Mr. Mays the right to continue exercising his statutory right to present challenges to the election board, and then from there to appeal to this court's decision, especially in light of the fact that part of what he was raising as even a challenge to his own candidacy by requesting a determination of the de facto nature of his candidacy is a constitutional issue that the election board could not, by its authority granted under Cherokee Nation Code, exercise. All it could do was simply rely on the precedent that this court has established that it's affirming today. So for this court to say that because Mr. Mays took new facts that he found to be potentially relevant in evidence, looked at the law as was a precedent before this court made its rulings, but were not addressed by this court in its decision, that it would be frivolous for him to bring his challenge and his claim and thereby award costs and attorney's fees to the respondents. Title 26, Section 37 allows every citizen, and it says, the right to challenge any candidate. Mr. Mays exercised his right. He looked at the issues that this court has decided and looked at new evidentiary material, looked at law that this court has expressed before it even made its decision that he felt was a basis for a challenge. If this court is going to award costs and attorney's fees on Mr. Mays by exercising his statutory right to issue a challenge based on new facts being continuously presented by the Department of Interior and precedent that was not addressed in its previous decision that this court at least should have addressed, but didn't, and it appears did not adhere to at all, then that would have a chilling effect on every citizen out there who may have a potential reason to challenge a candidate. What are we going to do now? We're going to start just letting the election board make every decision, and that's as far as you get to go, and ignore the right to appeal to the Supreme Court of any decision made by the election board, because citizens are going to be afraid of exercising their right, that because there might be a legal precedent involved that they may or may not be aware of, that they're going to be subject to an award of attorney's fees and costs against them for simply exercising their rights as a Cherokee voter. That decision is before this court, which it's taking under advisement. The only question that I have for this court for clarification is that this court has issued its decision again today, reaffirming the implementation of the 1999 Constitution based on argument that's been presented without actually accepting into this court or hearing argument about admitting documentary evidence as an exhibit. I would at least propose to the court that we would request to introduce on the record, since this court is issuing an affirmance of its prior decisions, we would request to introduce petitioner's exhibits A through D, those exhibits that I mentioned in my argument.
Is there objection from any counsel with regard to the admission of the exhibits?
There is, Your Honor. First of all, these exhibits are hearsay. There was a notice filed yesterday pursuant to Rule 807 that the court admit them under the residual exception to the hearsay rule. However, that I think was faxed to me or emailed to me about 1:30 yesterday afternoon, the morning before the hearing. Rule 807 is very specific. It says that there has to be reasonable notice and an opportunity to respond. So first of all, they're hearsay. Second of all, the court has already ruled that that issue is not before the court, and therefore the letters are irrelevant. Third, Your Honor, all of these letters are dated in 2006 and 2007, the affidavit. All of them were available at the time this court issued its decision in February of 2010 in the Smith matter. They were also available long before they were tendered with the notice of desire to introduce them into evidence at this hearing today. So yes, Your Honor, on behalf of Ms. Fraley, we do object.
Other objection?
And we approve the statement made to counsel for candidate Thorne.
Okay.
I had mine handed, these documents were handed me this morning when I walked into court.
Okay. What is the court's?
May I respond briefly?
As to the exhibits, you had another response, Mr. Garcia?
I had a response, Your Honor, briefly.
Very briefly.
In actuality, Your Honor, the way I read the rule when I looked at it, being so late yesterday when I sent it, was that we must provide notice so that opposing counsel at least can be prepared for that. We gave as much advance notice as we could to prepare for them with a specific notice of intent to introduce. However, counsel made my own argument for me. These documents have been around. These documents were attached to Mr. May's motion that was filed on the 12th. So counsel has had an opportunity to review these documents and be very well aware of them ahead of time before the actual specific, we intend to introduce them as a factual exhibit in this trial. So therefore, under 807, it would meet that exception. Additionally, under Rule 803, subsection 8, it is still, and I've got to pull that back up here again, it would still qualify for an exception to hearsay as, where did I find it here? A public record or statement of a public office, and it sets out the office's activities, a matter observed while under legal duty to report, but doesn't include criminal cases or any factual findings from a legally authorized investigation. Additionally, there is U.S. Supreme Court law that finds that due to the nature of a public official's presumption that they will perform their duties properly, that's Chesapeake and Delaware Canal Company versus the U.S., 250 U.S. 123, and then was restated under Fu versus McGrath 196 F. 2nd 120, that it's a presumption that a public official, U.S. Department of Interior secretaries, associate secretaries, directors, and associate directors are a public official, that they would act and perform their duties properly, thereby negating any potential inherent falsity or concern about what their truth and affirmance would be in those records or writings. Therefore, they would be admissible. Public documents from public officials are broadly admissible in court hearings. There's a lot of precedent other than those two that I've cited, so we would request for the admission in support of our argument of these 4 exhibits.
All right, the admission of the exhibits will be denied. We'll deny the admission.
I was asking the court for permission to address it before you ruled on the admission of evidence.
We're denying the admission. Do you still want to be heard?
Well, actually, I was going to encourage the court to admit the exhibits because the court has taken this opportunity to reaffirm its decision that the 1990 Constitution is the law of the land. It also will take in consideration the subsequent letters from the Bureau of Indian Affairs and Department of Interior and affirm regardless of their...
That Mr. Echohawk's letter?
Yes.
I believe he's left the Bureau too, hasn't he?
Counsel, for the reason that they are, not to interrupt you, but
Yes.
for the reason that they are in fact public documents.
Yes.
Everybody is aware of those documents. They were attached to the motion and filed with the court. They are in effect have been considered. We don't need them reintroduced.
Thank you.
I think so. They were referenced in the briefs, so we've considered them. But as far as the formal admission, we deny that. Agree? All right. Have we heard all argument? All right, we're going to take a recess for consideration of the matter. It is our intent to issue and come back with a decision to be followed up by an order. Be seated. All right, we're back on the record JAT 03, 2013-06, the matter of the